Yes, Mr. Kazi.
Thank you, Justice.
You were all still on Telesane's case.
And I think as I was talking about Teletsani, Justin Gorman suggested to me, well, we only get to the Teletsani kind of debate if we make out a case in our founding papers. And I want to I have to touch upon that because that's been the sort of the golden thread of the debate this morning in many ways. I want to make three important submissions in this regard. The first is, pleadings are there to protect parties having an opportunity to have a fair trial. That's the key reason for pleadings. And if the pleadings arrive at a court in completeness, in a manner in which there can be suggested to be no unfairness, then there can't be a complaint that the case wasn't made out in your answering affidavit or your funding as a matter of general principle. That's as a matter of general principle. Number two, especially in a case involving the liberty and the deprivation of liberty in general of someone, the general rules concerning making out a case in a founding paper and not amending, etc., are to be considered to be somewhat watered down or accepted, as I read to the court from Jibai. And number three, I do want to touch upon, which I have to do, what is stated in Zealand, because the Constitutional Court then said effectively what I've been arguing the whole morning concerning the pleadings point. I've got other pleadings points, but on this point. On page 36 of the small bundle, there's a paragraph 24, which says, and this is Langer, CJ, the Chief Justice, there's another more important reason why this court should rule in the applicant's favour. The Constitution enshrines the right to freedom and security of the person, including the right not to be deprived of freedom arbitrarily, etc. Accordingly, and this is I want to read from here, accordingly, it was sufficient in this case for the applicant simply to plead that he was unlawfully detained. This he did. The respondents then bore the burden to justify the deprivation of liberty, whatever form it may have taken. 25. This is not something new in our law. It has long been firmly established in our common law that every interference with physical liberty is prima facie unlawful. Thus, once the claimant establishes that the interference has occurred, the burden falls upon the person causing it. In Minister van Wet en Orde versus Mochaba, the Supreme Court of Appeal again affirmed that principle and then went on to consider exactly what must be averred by an applicant complaining of unlawful detention. In the absence of any significant South African authority, Groskopf J.A. found the law concerning the raven dicartia a useful analogy. The simple averment of the plaintiff's ownership and the fact that he or her property is held by the defendant was sufficient. This led that court to conclude that since the common law right to personal freedom was far more fundamental than ownership, it must be sufficient for a plaintiff who is in detention simply to plead that he or she is being held by the defendant. The onus justifying the detention then rests upon the defendant. There can be no doubt that this reasoning applies with equal, if not greater force under the Constitution. And here's the important paragraph. Even if the applicant be said to have altered his cause of action. That's how, Justice Gore, when you started with me this morning, there was no Rule 28 amendment. Even if that is so, which I do not accept to be the case, irrelevant, no prejudice will be suffered by the respondents if this court decides the case as it has now been presented. There's no prejudice. Nobody suggested any. Our learned friends' heads of argument don't suggest so. And as a matter of objective fact, there can be no prejudice. They've put before the court that which they wish to. They complained about urgency, they complained about joinder, all of those issues have now water under the bridge. And then it goes on. That is so because the question of the lawfulness of the detention is in the maximum security was canvassed both before that court, the High Court and the Supreme Court of Appeal, and there's sufficient evidence between this court properly to decide the case. We're in that territory. And we submit that on the pleaded facts, and when I say pleaded facts, that includes a reply which hasn't been answered, which hasn't been responded to. And if one takes the reply, I'm not going to read it, but I do just want to highlight the kinds of gomosol kinds of suggestions that are in the reply. And it will be demonstrated, we would submit, that these averments in the reply called for an answer. So on page 2110, it starts, page 211, 8.1, this application does not concern what happened in Tanzania. It does concern the lawfulness of South Africa's conduct in Tanzania. The Constitution requires that the respondents act in a manner that is lawful and consistent with their constitutional obligations, both domestically and internationally. And we know that's true from Kaunda. Then the next paragraph, and this is not responded to. So when we take the Zealand, Scots, JA, and PPC kind of ideas with Tantush, this we would submit called for an answer. On the respondent's own version, they have not done so. That is not acted constitutionally. It is clear from their answering affidavits they colluded with the authorities in Tanzania to secure my forceful return to South Africa in order to evade the extradition procedures provided for in the protocol. Indeed, respondent DHA makes it clear that there was an agreement between Tanzania and South Africa for my deportation. And this feeds in with respect to Justice Catherine Sitliani's idea. Was there collusion? Of course there was collusion, as a matter of fact. But it said so and it's not responded to. Paragraph 8.4. The decision by the South Africans to seek the extradition does not lie with any... Remember what happened here was the South Africans said to Tanzania, what do you want us to do? Should we bring in extradition? That demonstrates what is actually happening here. The South Africans justifiably, and I'll come back to it, wanted Bester and the appellant back in South Africa quickly. They know, as we all know, extradition takes time. There's questions of admissibility, there's questions of every, what some would say, stone trick in the book. We've all been down that road many times. So what did they do? They avoided their right, and we would submit obligation, and we would, under international, to use the SADC protocol on extradition to achieve that which they wanted. Bester and the appellant back in South African soil, arrested under the Section 43 warrant. That's what they did. There can be no doubt about it. And that is what he said in 8.4. But the decision by the South Africans to seek the extradition of an individual does not lie with any country. It lies only with South Africa. They did not need permission of or direction from Tanzania to nudge to follow the lawful extradition procedures provided for by the protocol. They were required to do so because that is the lawful mechanism for the return of sought persons to South Africa. Extradition disguised as deportation is not a lawful mechanism. It is inconsistent with both the Constitution and international. Let me just stop and remind the court what I started off in the beginning by saying, where there is serious crime, brutal murders, and what happened in this case could be regarded as a serious crime, there is a deep temptation to, as Chaskelson P. put it in Makunyani, or no, to use questionable methods on the war on crime. That's what happened here. It cannot be denied. There were questionable methods used outside the realm of the extradition protocol, the SADC protocol on extradition. Paragraph 8.5. Secondly, the respondents have not discharged the onus. The evidence of the respondent is contradictory. On their version, the relief sought falls to be granted as examples, and there's a whole series of examples. And for example, 8.5.2, next to the letter 8, line 18. They exercised control over me. I was not free to determine my own movement because they did so. The DHA respondent's version is fatally defective because South Africa's laws, etc., etc. So here the question is, was she free? She says she wasn't. And there's no comeback to that as a matter of pleading.
How does she respond to the issue of consent?
Consent. She says she didn't. But perhaps that's my next chapter.
Yeah, because you didn't, you haven't
It might be
dealt
next
with
chapter.
that one.
Consent constitutes a waiver of rights, if we understand it. And our learned friends have launched, or the police have launched an application to bring in the bail, what she said in the bail affidavit, to try to show that she waived her right to extradition, she consented. May I ask the court to turn to bundle page 18, small bundle page 18. This is paragraph 64. The onus to prove such waivers on the government. So Blanche and Christians allege Mohammed freely, if not eagerly, chose to go to New York in the custody of the FBI agents. Shabiri says, well, and we know, he says it in 2 paragraphs. This is the police defending Home Affairs. He says, and this is the high water mark of the point. No, just find it. Yes, it's pages 63 and 64. This is the high water mark of the waiver consent argument.
63 and 64.
63, paragraph 78.8, together with 78.9. That's the high water mark of the waiver argument by the respondent. By the police respondents, not by Home Affairs, by the police respondents. And the court will look at these 2 paragraphs and determine whether that which is set out in Muhammad in paragraph 64 was satisfied. So what Muhammad says, the onus to prove is on the government. To Blanche and Christian says that Muhammad was freely, if not eagerly, chose to go to New York. Muhammad flatly denied it, as does the appellant. So direct and one-dimensional, a dispute of fact cannot really be resolved on the affidavit, nor is it possible to ascertain a clear preponderance or probabilities in favour of the government version. Although a show of bravado, and remember what Muhammad did was he blew up a whole bunch of people in Tanzania in the war against the West, Al-Qaeda, Osama bin Laden type issues. And the argument could be by Mr. Blanche and Mr. Christians from Cape Town, they were immigration officers who hoodwinked Mr. Muhammad to go in. It's in the papers that he was a burger flipper at Burger King somewhere in the suburbs of Cape Town, and he'd applied for asylum because he said he was from somewhere in East Africa, and he had to go and renew his asylum permit, and he walked into the Home Affairs offices, and they said, come with us into the lift, down the lift into a waiting car, and the next thing he was on a plane to the United States. And of course it dealt with the death penalty. But the point is, although a show of bravado, so the issue is that, maybe he wants to go to New York, face this trial because his show of bravado with his fired by his religious fervor could explain why he would have opted for New York. It does remain curious that he'd willingly put his life in jeopardy. Nevertheless, notwithstanding this, we will assume in favour of the government that its factual version has been sufficiently established. This would still not assist for 2 reasons. Now the important aspects. First, none of the government opponents even suggests that Muhammad was aware of his crucial rights to demand this protection against exposure. Indeed, there's no suggestion that the South African government's officials concerned told him what he could do. Paragraph 66, in the second place, is a profoundly disturbing circumstance that on the government's own version, Muhammad was no time afforded the benefit of consulting a lawyer, etc., etc. Now the question arises on the papers. Where does one find any suggestion that the appellant knew that she had a right to contest extradition, knew that she had a right to be escorted out of Tanzania 3 days after the 12th of April? Nowhere. And Justice Cathby said, you asked the question, what should they have done? They should have read her and told her, these are your rights. If you are going to be sent to South Africa by a chartered plane by the South African authorities, you have the right to contest that, because that would be an extradition. And there are extradition laws, there's an extradition treaty, and therefore it would not, your so-called waiver of consent to deportation would run into the difficulty.
You mean to extradition?
I just want to make one point on this aspect.
Well, you have a right to
consent
hearing
to
first.
extradition, not to deportation.
To extradition.
Consent to extradition.
Yeah, no, she would have a right to.
Or consent to deportation, what do you say?
She would have a right to an extradition hearing, which she may or may not consent to.
No, so in other words, that she need to be informed that she could or needn't consent to extradition. You said to deportation.
No.
Deportation is a unilateral act by somebody else.
But the point is, she would need to be told a number of things. One is that she had a right.
No, I understand the point, but it relates to extradition, not deportation.
Well, deportation as well, and that's the point I'm coming to. She should have been told, which she wasn't, that in the deportation context, leave aside the extradition context, she had a right to leave Tanzania 3 days after the 12th of April. She was never told that.
Well, that would have been in the prohibited person notice.
If she only saw that for the first time on the 26th of May.
Yeah.
No, she says in terms, not deny, that she saw that document on the first time. And
in May.
In May, 26th of May. And interestingly, I know I don't want to. If one turns to the founding papers and you see her affidavit ends, I mean, I know this is something I've argued.
So,
for
sorry now,
shouldn't be true, what I'm not gonna-
are you leaving this point now, deportation, because you said that Tanzanian authorities should have informed her that she had the right to leave Tanzania in 3 days' time. Any other thing that you wanted
No,
to
I make 2 points about the well,
Yes.
there's one big point, which
Yes.
is she wasn't informed of any of her rights.
She wasn't informed?
Of any of her rights. No. Okay.
But assuming they knew that she was going to be facing prosecution, which she knew, I think it's common cause that they were quite aware that she
Let's
was
assume
facing.
that.
So could they have still carried out the deportation on the grounds that she was a private person, but say to her there's a possibility that you're going to be facing prosecution and these are your rights in respect to that. You're entitled to an extradition hearing. No, well that's gone because she's already gone across. It makes no sense anymore.
The
But
point
that
is,
makes no sense anymore.
on the 12th, when
Yeah.
what they should have done to come
Well,
home on this
for
way-
purpose, because now she's deported, right? And then she also consented, presuming, well, the state's case is that she also consented
Those
to
two
going
par-
back to South Africa.
Those are the 2 paragraphs which I've read to you.
Yes. So purposes of consent in relation to the deportation, what should she have been told?
I was coming to that.
Okay.
They
well,
should have,
yeah.
that's what I'd say. Leave aside extradition. So
Yeah,
let's
forget
assume
about
this-
that. Yeah.
They should have at least told her in the first instance that she had 3 days to leave. They didn't tell her that.
Here we're talking about Tanzanian authorities.
Yeah.
We're talking
Yes.
about Tanzanian authorities.
Yes, but we know why the Tanzanian authorities did that is because they were in collusion with the South African
No, I
authorities.
just want to establish whether we're talking about Tanzanian authorities.
Yes, no, but Justice Catherine is asking me what should have happened in the context of her. No, the police say, not Home Affairs, that she waived her right to contest whatever she was facing. That's the argument by the police. Our counter to that is she did not waive, she did not consent.
Mr. Katz, all I want to establish from you is we're talking about the authorities in Tanzania here. When you say they should have told her this, they should have done this, we're talking about the authorities in Tanzania.
Maybe the South African authorities as well. I'm not commenting on just this. It doesn't matter. If the South African authorities wanted her, then she should have been told of her rights, whether it be deportation, extradition, or otherwise. And that includes South Africa. Not just it's a unilateral act of deportation, I accept that. But then the question is, it's not my case that there was a waiver. It's not my case, it's the police's case. And I'm now saying to the court, there was no waiver of deportation, extradition, anything. And now the question is, well, what should have been done to achieve a waiver or consent? And I'm answering it by saying she should have been told the following rights, by whomsoever. And especially, for example, your Justice Mokoko, you make the point, by the Tanzanian authorities and the South African authorities on the night of the 12th of April. They were the ones taking her. They say it's a deportation. They should have said to her, look, you're being deported on the basis of this notice that was issued this morning. Have you seen it? And do you know that you've got 3 days to leave Tanzania and you don't have to come to South Africa? That's what the South African authorities should have told her.
Was that all they had to tell her?
Excuse me?
Was that all they had to tell her?
Well, in extradition, there's a lot more they should have told her. But I don't want to make a suggestion.
No, because here you're presuming the deportation Well, I mean, presuming there was deportation, plus there was also, the state says that she consented, and I'm concerned with the consent part. So in order for the consent to be meaningful consent, what ought they have?
Well, let me answer your question in two ways, if I may. I can try. The one way is knowing there is a possible prosecution on the other side.
Yes.
Then there's certain issues that need to be told. Assume it was one of these cases where the person is being deported, but they're not facing charges in any other country. They're just an illegal foreigner, they happen to be here. The first scenario, the court can get guidance from that which is contained in a consent. Let me just give the citation. What happened here was Mr. Spagney was in the US and he consented to come back to South Africa by way of extradition. And the neutral citation is 2023 ZASCA 24/13 March 2023.
Sorry, give us a...
Sorry. The neutral citation is square bracket 2023
Yes.
ZASCA 24/13 March 2023. And there are two judgments. The one is by Majali AJA and the other is by Dambuza JA. But in paragraph... So what happened? Let me just explain what happened. So he came back to South Africa having waived his right to contest extradition in the US. He comes to South Africa, and because he waived, he was now in South Africa. And my junior and I, Mr. Perumal-Sami, appeared on his behalf in this court, arguing that the South African extradition request to the US was unlawful. And this court found that it may or may not have been, but it was moot because he'd come back to South Africa and he was in South Africa having waived his right to contest extradition and consented to extradition. In the judgment of Majali AJA, she explains what he did when he consented. And there's a long piece around paragraph 19. As regards the argument that the extradition request continues to have legal implications, it is essential for proper consideration of that argument to quote the contents of his affidavit filed in support of his waiver of rights pertaining to extradition. They are as follows, and he explains in detail as to what he understood to be doing when he waived. He said, I am the person, this is the request, I accept the request, I want to go back to South Africa to continue the trial that I'm now facing in South Africa, etc. And there's useful information on that aspect. But assume, for example, Justice Catherine Sipioni, that that this is just a free person, if I may put it that way. No pending charges, no bad taste about the person, they just happen to be illegal in the country. In this country, the law is that the person may be arrested, and I emphasize the word may, pending deportation, or pending, I don't like that word, pending departure. The departure and deportation may have different elements. Departure is voluntary by the person themselves. Deportation has an element of state coercion. And in this case, because the person was prohibited, it's hard to, for the reasons that I articulated, it's hard to think away the South African charges. But we would submit the following on a very simple level. One, the person would have been informed that they had been found to be a prohibited immigrant. They had been given the notice of the 12th of April 2023, which she wasn't. And it would have been explained to the person that you have the right to leave Tanzania at any time before the 15th. And what is interesting is when has regard to the notice itself, there is a stamp.
Well, in South Africa, you wouldn't have had that immediate notice to leave. I mean, you would have had rights of appeal and whatever else. You would have had there would be a number of steps. But I suppose if you voluntarily decide to leave, then you could leave. But
well, we would submit similarly when has regard to the Tanzanian Immigration Act, which is attached.
Well, the basic proposition, Mr. Katz, is for any waiver, you need to have full knowledge of the rights you're waiving. You know, it's as simple as that, isn't it? We don't need to go into all sorts of detail.
There wasn't a waiver in this.
No.
No. That's the point.
But you're saying for purposes of, in order for her to have waived her rights to all the extradition rights, she should have been informed of what those rights were before she consented. I mean, isn't that your case,
That's the
basically?
case.
Well,
She wasn't.
you don't go that far. You simply say there is no indication that she was aware of any rights.
Absolutely.
Yeah, so she
And
was,
that's as far as one needs to go in terms of a waiver, is it not?
So I turn to Remy. May I turn? Yeah.
Was it ever established whether the appellant had legal assistance in Tanzania? Because I think somewhere the respondent is saying
I think at
she
some point
did disclose that
Yeah.
she had legal assistance.
She said so in her bail application.
Yeah, she said so. She said so. Let me put it this way. Whether she did or she didn't, it doesn't take that question of waiver or consent any further. But I find it hard to argue the requirements for full knowledge of the rights in a deportation context, bearing in mind the context of this case, with the crime hanging over the head in the
but basically you're saying that this was a disguised extradition. They used what? They basically used a mechanism that they shouldn't have, were not allowed, not permitted to use for purposes of being returned to the country to be prosecuted, basically.
And let me, and one of the aspects is which I would ask the court in its consideration to take into account is that this isn't one of those cases where there's no extradition agreement between South Africa and let's call it the other state. Because that can make a difference. Because here, the states had not only a right but an obligation to use certain mechanisms which are set out in a protocol. And they didn't. They went around the protocol. That's the point that is made in Alvarez and Shane. And that we don't think is unimportant for purposes of this case. So I do want to turn to...
Sorry, before you go further, Mr. Cos, there's something that sort of worries me, and is the following. Now, the allegation by the respondents is that she consented to her deportation. And to what extent does her bail affidavit support that contention by the respondent? Because I'll tell you what she said and what she didn't say in her bail application.
We say two things.
Sorry. Well, what she said,
Just on...
okay. All right. The allegation is that she said, I wanted to go back to South Africa to my children. And lo and behold, at that bail hearing, she said, I've got two minor children, age 11 and 6, respectively.
Paragraph...
Paragraph 7.3, setting out their family background.
Yes, I have that.
Okay. And then you said, I've got two minor children, 11 and 6. And then she further says, I have specific parental responsibility
Yes.
and rights with regard to primary care. That's what she says. She goes on to say, paragraph 7.6, paragraph 8 now, circumstances around my departure from South Africa. She says she was instructed and commanded by accused number 5, that is best to get into a vehicle and leave the premises to a destination unknown to her. When she refused, he forced her into the vehicle. She succumbed to the threats. She was defenseless, and she complied. That's what she says. She says, in any event, I had no reason to leave South Africa. That's what she says.
Yes, that's good.
Now, isn't that support at least the contention by the respondent that she said, I want to go back to South Africa to join my children, to be with my children, because of the circumstances in which she left South Africa. According to her, she was forced He didn't want to go to Tanzania. His pastor who forced her and put her into the car. She left her 2 kids here. She wanted now to go back to her kids in South Africa.
I want to make 3 submissions.
Yes.
The first is what is contained in the bail affidavit is a matter of principle irrelevant to this question of consent. And I pick up on Justice Corbyn's comment or understanding in Justice Cathry that waiver needs to be proved, and there's no suggestion that on the 12th of April she knew what her rights were. Whatever her mindset might have been, it's not proved that she wanted to come back to South Africa in the circumstances in which she came back. And let me just stop for a second while I'm on this point. And Justice Cathry Sipioni's point I'm going to come to, it's not a very good question, which I didn't answer in a way that I might have. Under the SADC Protocol Extradition Treaty, there are various rights. One of them is the right of speciality. And that right gives the person targeted in extradition the immunity, if that's the word, for prosecution for other than that for which they have been extradited. So if she says to the bail court, and that's what she says to the bail court, didn't want to leave South Africa, I want to be with my children, that doesn't mean that she should have been, let's call it, disguised extradition back to South Africa for anything to happen. And we know in the warrant of arrest, the Section 43 warrant, it's only fraud, but now that she's back, there are all these other charges. That's the first aspect of it. So even if she didn't want to leave South Africa, but was forced by Bester to leave, is not a reason to find that when she was confronted on the 12th of April, sometime later, that constituted a waiver because she wanted to be back with her children in South Africa. Number one. Number two, when she filed this bail affidavit, the day she filed it, and the court will see, the 29th of August 2023, she signed it on August 2023. On that date, there can be no suggestion that this case, the case that we're now currently dealing with, was in any way abandoned or dealt with anyone. I think at that point the petition was pending. And to suggest that not only did she waive her right to come back to South Africa, but she also waived or preempted her right in this case, we would suggest has no merit. So that's the import of the argument. That must be the consequence of the import of the argument that says, well, this affidavit endorses that which is contained in the 2 paragraphs in the police that's replying, or answering that.
Mr. Katz, on a factual level, if she was taken to a place where Home Affairs, police, whatever, and she said, I want to go home to South Africa, and they took her home, does that amount to a disguised extradition?
Yes.
Why?
Well, no, sorry. On the facts, yes.
On the facts.
She didn't know her rights.
No, forget about waivers. I'm not talking about waiver now. I'm talking about the fact that she's brought into what was it, the South African...
No, it was the airport.
Okay, she was at the airport, and she says, I want to go home.
No, I'm not sure she said that.
Well, I want to be with my children, she said.
That's what she says.
Yeah.
She said the following.
At Kilimanjaro Airport.
She says, this is what he said. It's on page 63, 64.
64, the applicant informed all and sundry that she wanted to return to South Africa to her children.
Yes.
So I want to go back to South Africa to my children. Does that then form the basis for a disguised extradition?
Yes.
If she volunteers that, is she still now actually, you say, that's amounting to some kind of waiver?
No, I'm saying it's not a waiver.
No, I'm saying that you have to prove a waiver.
Yes, that's
Still, in those circumstances, where she comes to these people and she says, I want to go back to South Africa to my children.
Yes.
There's anything wrong with that if she then gets taken back?
Well, all I can do no better.
That's the case of the respondents, Mr. Katz.
Yes.
That's the case of the respondents. I want to go back to South Africa to be with my children, or to my children. And
I'm now just So I have two responses. Firstly, as a matter of principle, that's not good enough.
Sorry,
It's not good enough to dispel the notion that this was a disguised extradition as a matter of principle.
why is that?
Well, in the circumstances, she's at the airport and she says, this is assumed she says, I'm assuming
She's serving an economy passenger flight, Mr.
Excuse me?
Okay. She's serving an economy passenger flight.
And
No, I'm
you
being
know,
facetious,
you
but
and
I mean,
I are paying.
am I asking?
You and I are paying for her economy flight.
Sorry, that really was facetious. But is there anything wrong with her in those circumstances saying, I want to go back? And basically in her mind, I've been abducted by this bloke here. I want to get back to my children. She says in her bail thing, I was also practicing at my clinic until such time as I was,
Yes.
Yeah. Now, she's unlawfully abducted,
By
on her
Besta.
version, by Besta, yeah. She gets to Tanzania. She's suddenly arrested by the Tanzanian people because she's actually unlawfully there. South African people pitch. Let's just put it at that level. And she says, I want to go home to my children. What is that? Is that an extradition? Is that a disguised extradition?
Well, let's put it this way. Perhaps I should spend some time on the point. There's a judgment of Justice Pruneman called Vella, which we've included in full in our bundle. I have to, at the outset, say that in a case called December, this court found that Vellum was wrongly decided.
Yeah.
But the proposition that Justice Pruneman articulated,
That was the Transkei, or Ciskei rather, something like that. Yeah.
I'm just looking for where it is. It's on page 26 and following. I just want to make the simple proposition that where the, let's call it the extradition stroke deportation is achieved by way of craft or cunning, those are the words that Justice Pruneman uses, that in and of itself amounts to unlawfulness.
Is that shown on the papers here?
Yes.
Craft or cunning?
Yes.
On whose part?
On the South African side. They
Why?
turned up, as Justice Ward, when you put it, they pitched. What were they doing there?
They were there to get Besta back. Let's just leave it at that.
Well, have you seen what, then you have to look at what she says in the replying affidavit. The court cannot ignore what she says in the replying affidavit. So when I argue this case, I'll argue it on her version, included in what's in the replying affidavit, without an answer. So we can't suck out bits and pieces of what the police say and Home Affairs don't say. There's no explanation of who she said it to, all and sundry, by policemen. What does that mean? And what did they tell her before she said, I want to go home? Maybe they said to her, well, you're going back to South Africa, and maybe she said, oh, well, if that's the case, I'm looking forward to I want to go home to see my children. We don't know.
Well, they were brought to court on the basis of an unlawful arrest by the South African police on the 6th of...
Absolutely.
That's the case that they were brought to meet, and they go into all the sound detail which they didn't need to go into. Saying, I want to go back.
No, Zealand says the exact opposite to that which Justice Gorban, you suggested. It said she did enough. And Jibai confirmed...
Once she's proved of her deprivation of liberty, yes.
She was deprived of liberty.
Well...
And she says, I can't do better than
I
what
think
she
we've
Yeah,
gone
we've
through
done
that,
that.
Mr. Katz. I think the point is, I mean, this is not a case which falls within the Ibrahim type of situation. Would you agree?
No.
Because in Ibrahim, it was clear agents of the apartheid South African government abducted Ibrahim and brought him to South Africa, and he was arrested in Pretoria ultimately.
I can't disagree with that. Those are the facts there.
Yeah.
Yeah, so it takes out, the facts take it out of that realm of abduction, apprehension in a foreign country. Isn't it?
I'm not going to, I'm not going to deviate from our position
Yes.
that what happened to the appellant on the 12th of April 2023 in respect of the conduct of the South African authorities was unlawful and unconstitutional.
All right.
That's the
I
argument.
think that we've made the
I think
point
we
there.
understand that.
Thank you.
And I've made the point that I cannot make it any further that the we must be careful as a society not to. Well, she did a terrible thing, and then, as the Constitutional Court says, use questionable means to combat war and crime. No matter how we put it, it not be as the Alvarez Machine type or the Ibrahim type, but it's a principle. They wanted her to stand trial. There was an arrest warrant waiting for her. And what did they do? They agreed, they colluded with a foreign state to achieve that. That's the bottom line. And when one talks about an apartheid state, of course, I won't say it's different, because here and I made the point in my introductory paragraph, the executives of the world must be careful, and the courts are there to ensure that this type of conduct doesn't take place. I do want to come to 3 points, and I've exhausted my time. The first point is, attached to our heads of argument, there's the judgment, the speeches of the House of Lords, and in particular the majority speech of Lord Griffiths.
Sorry, your heads of argument, you say?
Attached to our heads of argument. It's in, I'm just hoping this one's correct. It's in our small bundle of today. We gave it to, it's in the small bundle of today, so you don't actually, no.
I think in the original bundle of authority.
No, sorry, it's a bundle of authority attached to our heads. That's right. Original heads.
Yeah.
And we ask, and Hosbury, the facts are always interesting. He was in Cape Town, and he was wanted in New Zealand. So he found himself on a plane, being open quote deported to New Zealand. But we know that South Africa doesn't have direct flights with New Zealand. So the flight went from Cape Town to the UK. He got off in the UK, the next thing he was facing trial. No abduction like Ibrahim, no abduction in the sense of Alvarez Machine. In paragraph, undumbered paragraph on page 39, page 61, next to letter H. Lord Griffiths, for the majority, says, Your Lordships are now invited to extend the concept of abusive process a stage further. In the present case, there is no suggestion the appellant could not have a fair trial, nor could it be suggested that it would have been unfair to try him if he'd been tried or returned to this country through extradition procedures. If the court has the power to interfere with the prosecution in the present circumstances, it must be because the judiciary, and we would submit that the 5 wise justices, accept a responsibility for the maintenance of the rule of law that embraces a willingness to oversee executive action and to refuse to countenance behavior that threatens either basic human rights or the rule of law. My lords, I have no doubt that the judiciary accept this responsibility in the field of criminal law. The great growth of administrative law during the latter half of the century has occurred because of the recognition by the judiciary and Parliament alike that the function of the High Court to ensure that executive action is exercised responsibly and as Parliament intended. So also should it be in the field of criminal law. And if it comes to the attention of a court that there has been a serious abuse of power, it should, in my view, express its disapproval by refusing to act upon it. Let us consider the position in the context of extradition. Extradition procedures are designed not only to ensure that criminals are returned from one country to another, but also to protect the rights of those who are accused of crimes by the requesting country. Thus, sufficient evidence has to be produced to show a prima facie case for the crime. This is the important point. If a practice developed in which the police or prosecuting authorities of this country, and you can include Home Affairs, ignored extradition procedures and secured the return of a person by a mere request to police colleagues in another, they would be flouting the extradition procedures and depriving the accused of the safeguards built into the extradition process for his benefit. It's, to my mind, unthinkable that in such circumstances the court should declare itself to be powerless and stand idly by. I echo the words of Lord Devlin. The courts cannot contemplate for a moment the transfers to the executive of the responsibility for seeing that the process of law is not abused. And we submit that on all grounds the process of law was abused. Now I do want to turn to that, and I just want to, in our heads of argument, we make the point that Vellum which is the Craft and Cunning point, was overturned or rejected by this court. Now, I want to make 2 points. One is those cases are distinguishable. We make that point in our heads of argument, and we say they're distinguishable because in December and Mahala, unlike in this case, and in this case the High Court found that there was unlawfulness. In those cases, the court found that there was no unlawfulness in the obtaining of the person in Ciskei and Transkei, whatever the events were. The second point that I wish to make is this. We've attached and we've referenced various articles, academic articles with reference to international law by Professor John Dugard and others, which said those cases were aberrations. Firstly, that the events there happened prior to the Constitution. But if this court rejects the appellant's appeal for any reason, we would say this court is going back to pre-Ebrahim days. And that's not something that we would suggest is something that the Constitution would be inclined to endorse. The last point that I wish to make, so we would say that Vellum is the standard bearer for the type of argument that I make about Craft and Curran being the extension of Justice Makhotho's Ebrahim point. The last point that I want to make, which is the last chapter, and this is not in our heads of argument, it's a new point, and it's a response to an argument which at first blush might be attractive, but we say it's got no merit. And that is this. The police say the following. If you are with us that this was a disguised extradition and it was unlawful, nevertheless, under section 172(1)(b) of the Constitution, this court should exercise its remedial power to grant a just and equitable remedy and give, open quote, the trial court's jurisdiction. And there seems to be something attractive on the point from a public opinion point of view. Well, the government acted badly, this was a disguised extradition, but the appellant should not get off. Which is the rule. The rule is a disguised extradition, the trial court will not exercise jurisdiction. So they say there should be this just and equitable remedy.
Well, they're saying you must balance all considerations.
Excuse me?
They're basically saying in granting just and equitable relief, you need to balance all the considerations. Yes. So you've got to take into account the victims of the crimes and their families.
That's what they say.
So, and what is your point on that? Yeah.
Justice Untalte in the Constitution Court explained the problem. The problem is that's reverse engineering, he called it. Because this isn't about balancing of rights in this sense. This is about jurisdiction. And jurisdiction is a binary concept. Either the trial court has jurisdiction or it doesn't. And if it doesn't have jurisdiction, 172(1)(b) can't give it jurisdiction. And in this case, we're slightly different on that point, but the principle is there. And it's page 50 of our bundle. He says, for these reasons, I conclude the application before us must fail. The Constitution does not give this court the power to make the declaratory order sought, so as then to entertain an application for leave to appeal from that order, about an Equality Court order which wasn't followed up. Nor is this court competent to enforce the applicant's rights of access to the Equality Court when the applicants have not moved the Equality Court. I appreciate that the applicants have with much persistence requested the presiding judge in the Equality Court to convene. His failure to do so is to be deprecated. What is required is an application brought urgently to that court. Now, if we turn up in the paragraph, so that's the background to what actually happened. So what the Equality Court wasn't listening to the Social Justice Coalition. They tried. And eventually they gave up trying and they went straight to the Constitutional Court. And in paragraph 149, he deals with this, we would submit, firmly with the kinds of argument that the police have produced. It follows that this court is not the competent court. If I find, and this is next to the letter, between the letter A and B, as I find this court therefore lacks jurisdiction to entertain it, there can be no basis to source its jurisdiction by recourse to a determination that the applicant's rights have been infringed in the wide remit of section 172 that gives the court the power to make an order to cure that infringement. Jurisdiction is a binary concept. A court either enjoys it or it does not. This court cannot simultaneously lack jurisdiction in terms of section 38, but enjoy jurisdiction in the 172 point. Section 172 makes this clear. When deciding a constitutional matter within its power, is the introductory words to 172, this court must enjoy jurisdiction to decide a matter. If it does, only then may it exercise the remedial powers. The first judgment holds in the proposition that if a minority is required to make good an infringement, this court enjoys jurisdiction. And an important sentence, that reverse engineering of jurisdiction is not, in my respectful view, a tenable interpretation of the Constitution. And that was for the majority.
So, what is the citation of the case? Because you said it is not covered in your case.
Excuse me? The
You said
citation is
this
on the
case is not
left-hand side.
Covered in your case.
It's Social Justice Coalition and Others versus Minister of Police and Others. It's reported in 2022, Volume 10, BCLR, Butterworth Constitutional Law Reports 1, 2.
Sorry, you're going so quickly, Mr. Scammon.
Excuse me?
Just slow down, please.
No, it's on page 49.
Oh, it's on your page. Is it
page
here?
49.
Oh, okay. Thank you.
So the point is,
Okay, it's 40.
the simple proposition is, a learned friend's argument about 172 being, in this court being invited to exercise 172 powers, would be what we would submit would be reverse engineering, and not contemplated by the Constitution as a piece of report.
Thank you. Okay,
Thank you.
thank you, Mr. Carter.
Thank you for allowing me.
Yes, Mr. Stillenberg.
Thank you, Justice.
Yeah, you had a debate between the court and Mr. Carter.
We followed the debate, so
Debate, but yeah,
thank you, Justices. We started the by stating the obvious, which one should never do in starting a conversation. Each case on its own facts. In this matter, the applicant is not and was not a layperson coming to court saying, somewhere during the night I was taken, I don't know why I was taken, I don't know by whom I was taken, and I was detained and I was deprived of my liberty. The applicant had a very fact-based case, set out in detail in paragraph 8 of her founding papers, stating that on 6 April she was abducted by the South African Police Services. She didn't say she was not sure who to go. She never said so. In fact, if justices have regard, this becomes important with regards to the pleading argument. To the DHA, that was the 6 respondents, answering affidavit, they appended to that affidavit at page 160, a letter that was drafted by the appellant's attorney, the representative. This is the 23rd of May 2023, after the founding papers were filed. Court will bear in mind that it was done on an urgent basis. The respondents were under severe truncated periods to respond, and yet DHH address, they respond to letters apparently addressed to them by DHH, wherein DHH explained, if one looks at the reply, what according to them transpired. And the upshot of this letter is that the appellant says 2 things. 1, your version is not true. My version is contained in my founding papers. 2, I'm not going to join you. So if you want to join the proceedings, feel free. But I don't have any issue with you. Whilst in this letter they list why on that explanation they think it would have been an disguised extradition. What the applicant did not do.
Well, what did she ask in the letter? Who was involved from the DHA?
She
In that
asked
letter?
nothing in the application.
No. So this letter you're talking about, the 23rd of May letter. Yes, what was the significance
they
of that
asked her to
letter?
withdraw the matter.
Sorry?
They asked her to withdraw the application against them, and she said she's refusing to do so.
Oh.
And if
Oh, was
they
that the
want
letter
to-
from the
but
state
23
there?
May.
no,
I thought she wrote it.
he's still under immunity, you remember. 10 minutes.
Oh, I
immunity.
beg your pardon, sorry.
That's not a problem. But that letter was addressed by the appellant's attorneys to the to DHA,
Even I was holding back.
And she quite pertinently says that she refutes what they say. That's not her case. Her case is quite clear in the founding papers. And if they want to place that before court of anybody else, they must do so. She does not file a supplementary affidavit. She does not amend the relief she seeks in any manner. She does not bring an application to expand, which we suggest is what she should have done, the basis for the relief and founding. She just leaves it. The relief, as Ms. Gorman pointed out in the notice of motion at page 1, was never altered, was never amended. There was never an application to do so. So when one looks at page 290, that is a notice of appeal, one is quite surprised that without any application to this court, there is an attempt to say that this court must now grant different prayers from that was sought in the court of quo and what the respondents were asked to respond to. Not only is a sixth respondent introduced into the prayer, but there are also now declarations with regards to acts being inconsistent with the Constitution. And we also know that the prayers was also contained in the heads of argument. What the respondents contended from the start is, and nothing that we'll just show the court that it's not correct that this has been disturbed by any court. Before there's any reverse onus in matters like this, the appellant must show that her liberty was deprived and that she must say who did so. And we've referred the court to the Mkhlangu and another Minister of Police judgment, for one, which says that once the plaintiff has to establish that an interference has occurred. Now, how do you do that? The appellant told us how she said it was done and by who. Once that has been established, there's a factual dispute here. Then there's a justifying onus resting on the respondent. Now, the mainstay of the argument became that because the South African police services were present in Tanzania, if I understand it correctly, when a handover took place, therefore by part of the arrest. But that does not track with the evidence. For example, paragraph 69 at page 60. This is the answering affidavit. SAPS members travelled to Tanzania on the DHA plane, did so for purposes of providing escort to the DHH officials. After all, the applicant was in the company of Bester, a man who has been convicted of murder and rape. These SAPS members did not travel to Tanzania to arrest the applicant. Cannot be stated in more unequivocal terms. Page 64. At paragraph 78.10, the appellant was never arrested, as stated, nor was she handcuffed at any point before or during a flight from Tanzania to the Republic of South Africa by the SAPS. She's being utterly untruthful, with allegations that she was blindfolded and abducted. Nobody flanked the applicant in the sense that she conveys. There are only the limited number of seats on the plane. They also go further to state that there was also no defense. Then we get the 6 respondents. Affidavit, page 142, paragraph 26.
Sorry, page?
Page 142, paragraph 26. Members of a special task force and the official of the correctional services were mere spectators during the handover process. Can't be more clear. The applicant was at no stage blindfolded as alleged when she was handed over by Tanzanian immigration officers to the High Commission. Page 146, paragraph 40.2 of that affidavit. The applicant was not arrested by members of SAPS in Tanzania. She was arrested by Tanzanian police. As indicated above, her arrest by a member of the SAPS was effected upon arrival at the Lanseria Airport in South Africa. Return the page to 147, 41.2. The second applicant was handed over to me, the deponent to this affidavit, Mr. Matthews. And the handover notice was signed by me. This much is clear from Annex DH A7C. Third, no member of SIPS in full uniform arrested the applicant in the manner alleged by the applicant. I, in any event, would not have allowed such conduct from any person. The Tanzanian immigration officers have made it clear that the applicant investor would not be handed over to members of the SIPS and or transportation belonging to the South African Police Services. So, not only has the appellant not established her case, which she set out in paragraph 8, we also know from the uncontested evidence, the evidence that we must accept, from both DHH and the first to third respondents, that the South African Police Service in the first place never went to Tanzania to arrest the applicant. They were there, they were observers. They never did anything akin to restraining her, abducting her, first forcing her onto the plane. And there is nothing in the papers on which the appellant can rely that refutes this. Now, she says that, well, these are sui generis proceedings. Once she has complained that her liberty has been limited or taken away from her, there's a general onus on the respondents. But in this matter, she took the first to third respondents to court. And that is the case that the respondents had to answer. And that is where Tseletsani comes in. Because the fact that they go further, but they didn't go further in the sense that they were in any way implicated in any unlawful or underhanded conduct. There's no merits in any argument to say that they coerced or used stealth to lure the applicant to get on that plane. Nothing. There's no conduct whatsoever on the part of the SIPS. If we accept the respondents' versions, that brings them within the Ibrahim sphere. Not even in the other matters. Just as if we look at the applicant's affidavit, she came to court with a set of facts, which she then totally abandoned. In this appeal, she doesn't touch on the case that she made in finding. She relies solely on what she said in reply. And the accusation now is, but you should have come and asked leave to file a further affidavit to respond thereto. Why would I file an affidavit or ask leave to deny something that she denies, which I've already positively asserted on oath? Knowing what the rules of the game are, so to say. Why would anybody do that? It doesn't work that way. That's the first issue. The second issue is, now we know that the parent says she was taken against her will from South Africa. She didn't want to leave South Africa. She's a doctor, she's got a practice, she's got 2 kids. She is the primary caregiver. They reside with her. She had nobody to complain with. She finds herself in a foreign country, in Tanzania. Here comes the South African deputation. There's a plane. And she says, I want to go home. What should they have asked her? Should they have said, no, we're leaving you here? Why should they have informed her of anything? She says, I want to return, and now we know why she wanted to return. She wanted to come back to her children. That's always been the first to third respondent's case. It's never been anything different. And what is wrong with that? What is unlawful about that? Nothing. And none of the submissions that have been made detracts from that case. It's not, it hasn't been in any manner on the merits been challenged. It can't be challenged. It's just simply denied. But we know why she did what she did. So she wasn't arrested and forced onto the plane. She hitched the ride, to borrow a term, but that's exactly what happened. Why was the police there? We know that as well. Everybody knows that. Because there's a convicted rapist and murderer, and it's going to be escorted back in a South African plane with South African officials. So that precaution is quite reasonable to take with respect. And That is as simple as this case is, on the law and on the facts.
Okay, I just want to warn you at this stage that you have 10 minutes of immunity is now up.
More
You may
welcome.
start expecting questions from the
Yeah.
members of the board.
Yes,
Mr.
sir.
Sandberg, in the answering affidavit, there's reference to Section 41 and that the DHA and the police
depart-
acted in terms of
Yes.
Section 41. What do we make of that?
Justice, I can't really, I can't speak on their behalf. I think one has to see these facts in the proper context. I think Justice Gorman said they were probably mistaken, but
They were
that's
mistaken.
not,
I'm
But
not
it
sure
doesn't-
it's neither here nor there as far
Yeah,
as the appellant
okay.
is concerned.
It's just a neutral fact that
It's
we don't
just,
need to...
it's just a nice thing for an unsuccessful litigant to raise when you want appeal, but it doesn't take this matter anywhere.
Sorry, and on your case, the deportation by the Tanzania, well, it was the deportation was carried, the arrest was carried out by the Tanzanian government.
Just
not the
as
South
sake
African.
for inferences, for arguments that are raised, that whole issue with regards to disguise expeditions.
No, sorry, I'm still asking the question. So basically, you were saying there was nothing wrong with the deportation by the Tanzanian government. I mean, that is not what's in question here.
They decided to deport.
So basically, the deportation was lawful.
Yeah, they took a decision to deport her. She said, I want to come home. She got onto a South African airplane.
Yeah.
She came
So,
back
so,
to her
so,
kids.
so having consented to coming home, then was there any duty to basically inform her of what her rights are
Why?
in relation to the fact that she may be prosecuted
The
in South
answer to
Africa?
that is simple. If she says, I want to go home, why would I say, wait, before you do so?
Yes, but in the Mohammed case, remember,
But
Mr. Mohammed said
was-
he wanted to go. He volunteered to go.
Yes, but
Right?
there
On Facebook.
the Concord,
But then there was the issue of the death sentence
Yes,
and whether
that
he could
was,
actually give consent in those
that was
circumstances.
a big issue because
Yes.
what the Concord quite expressly stated is they doubt that anybody would ever be able to consent to capital to be delivered to a state where there's capital punishment. Remember, Justice, also the other distinguishing trademark of Mohammed is that he came to our country illegally and we sent him to not to his home country, but to another country, to the United States, who had the capital punishment for the crimes that he committed. But Mohammed, the Constitutional Court, had no problem with consent whatsoever. It was the facts of that matter that raised the eyebrows.
Yeah, but it was the pivotal concern was that he'll face the death penalty. And how can you possibly consent
Yes.
when
Which
that
is
is
a
something
valid
that is
point.
facing you? Huh?
Which is a valid point.
Mr. Stellenberg, the analogy was given in one of the cases relied upon by Mr. Katz of the Ray Vindicatio. But in a Ray Vindicatio, you need to prove two things: ownership and that the person from whom you're claiming it is in possession.
That's what
So the analogy here would be surely you've got to prove I was deprived of liberty. And then the owner shifts to say, well, I've got better title under the Ray Vindicatio to you to hold this as possessor.
the Concord
But surely
actually
you've at least got to say, I was deprived of my liberty. Ibrahim, it was obvious, it was deprived. All of those cases.
Smith versus Rubenstein. Leading and evidence.
All of those cases. So there's no immediate onus,
No.
simply because of an assertion.
Yes.
You need to be deprived of your liberty by the person concerned. I mean, it's a complete defence to the Ray Vindicatio to say, I'm not in possession, my brother Mahoka is in possession. That's a complete defence. I'm not in
That's
possession.
correct, Justice. And that's also
This is the
reason-
similar analogy, is it not?
But
The
that's the
police
reason
are saying,
the
we didn't do
Concord-
anything. We did not arrest.
Yes, exactly.
And there's not a jot or a tittle of words about the Home Affairs in the founding papers, is there? No.
And Justice, that analogy that you just raised, the Constitutional Court actually adopted in the case we'll refer to. They adopted that, and the case law that the colleague referred to, in the sentence before, the sentence very long, refer on all the old, well-established right cases with regards to deprivation of liberty, which states exactly this. So to just take that sentence as meaning something more, we respectfully would joint issue with.
Mr. Stellenberg, that letter of the 23rd of May that you referred us to, I mean, her response there was quite clear what the case is, that she was arrested and abducted by the SAPS, am I right?
Yes.
So it was a reiteration of
Yes.
her case once again.
Yes, Justice. Her response was, "You lying. I don't accept what you
Yeah.
say. It's not true. My version is in my papers. Do what you want to, so to say." So she's in a totally different position than any other plaintiff in these circumstances in any event. But the one thing she cannot come to court to say is, because we get cases like that, where a person says, somebody came to me, he forcefully forced me into a vehicle, and later he sits in prison, and he knows, well, I was apparently arrested. I don't know for what. It was a plainclothes officer. Those circumstances, by all means, the rules of the game is different. But in this matter, it's not. This is just a point we want to make. If the amendment that our learned colleagues now sought, if the court is not with him on certain points, that would mean that relief is taken away from the only parties against which it was sought in the court quo, and it will now be granted against the party against it was never sought in the court quo. You don't understand the laws of litigation to quite countenance that, because
And who you specifically, pertinently decided not to join in the matter.
express election.
Yeah.
Express election. Yes, I was just, I think I did make this clear, but that letter from in reaction to DHA that I refer you to was 3 days before the first to third respondents filed their answering papers.
3 days before.
3 days before that already. She knew exactly what DHA would say.
It was 3 days before the respondent filed its answering papers.
Before the first to third respondents filed their answering affidavit, and after only, Justice, you will recall, everything happened in a very rushed manner. There was a joinder by DHA, and they then filed their affidavit thereafter. So she made an election not to expand the case, not to seek alternative relief against them, not to amend the prayers. That also features prominently in the application for leave to appeal in the judgment, where the constitutional attack comes in. But yet again, there was never any attempt to amend, to even amend the prayers.
And on the Ray Vindicatia analogy, if the person who I point to as being in possession decides to join in the action and says, well, this is what I did, and it actually fact amounts to them having possession, unless you amend the relief, you still can't get relief against them.
Yes, that's exactly so. So just maybe make a comment with regards to this. We submitted that this matter shouldn't get here, but just with regards to the case that I learned colleague, we got notice of it this morning. I'm not objecting there too. But the case Judge Interhalter was dealing with was dealt with statutory jurisdiction. Here we're dealing with a matter where a court, by declaring certain conduct unlawful, says, well, this court will not have, the criminal court will not have jurisdiction over you. It's something different. And we know what Section 172 says. When conduct is declared unlawful, the court has the powers in terms of 1B.
It's a wide discretion to be exercised judicially. I'm really not sure that this argument helps you too much, Mr. Snellenberg, but perhaps one doesn't have to get that far.
Yes, but there's, I think, Judge Tuan pointed out, there are a lot of interests that are in play.
Well, and
the
part of
court
that...
either has jurisdiction or not. You can't.
But
You can't say this is not statutory jurisdiction, so it doesn't matter.
Yeah, this point with regards to jurisdiction in Abraham was said, well, because the state hasn't brought you before court with clean hands. But we also know there's a lot of case law that says that an unlawful arrest doesn't mean that the prosecution is unlawful or void. So it's not as clear-cut, we respectfully say, but we understand totally what the rationale for the room was. We don't have an issue with it at all.
So basically you're saying the criminal proceeding should continue. That shouldn't be rendered a nullity.
Prosecution should be able to continue.
But she
with
should be released and the prosecution should continue.
if we get to that.
But I've got to say that Ibrahim is the gold standard for me still. You know, I mean, if that's the situation, the rule of law demands release on the basis of no jurisdiction. So for me, it would run counter to that notion to invoke some sort of discretionary relief which actually abrogated the rule of law. That's the point I'm making now in relation to the law.
I must confess, we were not totally prepared for this argument.
No,
This is
yeah.
what we've been able to say, but we do respectfully submit there is clear distinguishing factors between the judgment of Judge Gerald, Justice Gerald. But
It's akin to the powers that the court has in terms of Section 173. Those powers would not allow a court to exercise jurisdiction where it does not have.
no, our submission is purely that we look at how the incompetence arises as a result of a finding of unlawful conduct. Obviously against the facts of the matter, but I'm not going to labour that point. I'm not that well prepared to do so. I just want to, we can at least make a submission that there is a distinction between the matters.
Pointed. Any further submissions?
If it is good.
Thank you, Mr. Nodek. Anything in reply, Mr. Katz?
Just 2 points. Thank you, Justice Sonja. Just 2 points. The one point is the question of amending relief. And this court and the Constitutional Court have over and over said that in a case such as this, the court, and for that matter the respondents in a case such as this, are not bound by the form of relief contained in the notice of motion. And what the court will do is consider the pleadings as a whole and give the appropriate constitutional relief that sorts from the papers.
So in the Ray of Vindicatio example, B, who comes to court of his own or her volition, and it becomes clear that they've got possession, without any amending of the relief, you can actually get an order against them, you say?
Yeah. Well, against the other party.
Yes.
Of course, in a constitutional matter of this kind. That's what Zealand says. It says it in terms, effectively, in paragraph 26 on page 37. How can it be otherwise? They're not here. And in any event, the main relief, the main relief did not exclude them from the attack. So on page 1, it doesn't talk about the police.
No, but the case made out is the police only. There's not even a mention of NHA, of Home Affairs.
No, sorry, with respect to the Ray Vindicatio scenario. I come against you for a Ray Vindicatio. It's my property, you've got the property, ask the court to order it back. And your defense is your brother next to you has got it. And your brother next to you is a party to the proceedings and files an affidavit explaining whether he has it or not. Of course the court has got jurisdiction to grant an order against your brother.
Without an amendment.
Excuse me?
Without an amendment.
That's what Motorclip says. It's exactly what Motorclip says. Twice. It's in this court by Haram's J in paragraph 18. It's paragraph, read from Motorfontein. This is this court. Paragraph 18.
Of which judgment?
Excuse me?
Which
judgment? It's in our heads of arguments called Motorfontein Squatters versus Motorclip Boerdery 2004, volume 6, SA 40, and in particular paragraph 18. And by the way, the Constitutional Court affirmed this in the appeal to the Constitutional Court, judgment of Langa CJ. In paragraph 18, I'll just read from, well, let me read the whole paragraph. In light of the foregoing, it is not surprising that at the hearing before De Villiers J, Motorclip and Agri SA accepted that the unconditional removal of occupiers was not a viable option. Instead, they proposed an order in 2 parts. The first, a declaratory order relating to the state's constitutional obligations toward not only Morika but also the occupiers, and the second part was a mandamus requiring the state to submit to a comprehensive plan. In the court below, the state objected to the new direction, wishing to hold Morika to the relief originally sought. It's an echo of what we've heard here. The objection was overruled by de Villiers J, correctly so. If a constitutional breach is established, this court is, as was the court below, mandated to grant appropriate relief. A claimant in such circumstances should not necessarily be bound to the formulation of the relief originally sought or the manner in which it was presented or argued. That much is apparent from the course the litigation took in Carmichael and Ballantyne, and why the further amici, the Nkuzi Development Association, the Community Law Centre, the Programme for Land, etc., were admitted to the proceeding. So the simple proposition is what this court has as a factual matrix is, I'm going to leave aside the police for the moment, but as a factual matrix, we have the DHA relying on an incorrect section, an incorrect understanding of the status of the High Commission, and without giving an explanation of what powers they were exercising when the handover took place. How can it be said that, bearing that in mind, the appellant fails because they haven't properly identified the issues, when in paragraph 1 of the notice of motion they don't mention the police or Home Affairs, they say the state?
Sorry, when you say an incorrect understanding of the High Commission, can you just elaborate on that?
Well,
you just use the term.
Yes,
they had an incorrect understanding.
Very clearly. Santos versus Santos is a case in which it is said there was a debate about the status of the territory of a foreign embassy or high commission. And the courts all over the world, including the Vienna Convention on the Law of Diplomatic and the diplomatic communities, etc., say that a foreign embassy is not the territory of the sending state. It's the territory of the home state. Now, unfortunately, the third secretary makes the mistake on page 179, and this is it's all parcel and parcel of the same thing. I'm sure I'm arguing. On page 179, paragraph 9, this is what she says. In simple terms, the premises of the High Commission are regarded as the South African soil and property that of the government of the Republic of South Africa. And then she attaches a copy of the Vienna Convention. And then she goes on in the affidavit to say, in paragraph 10, there was a meeting on 9th of April at the premises of the High Commission. And then and her reasoning is because this thing took place, this meeting and the various aspects took place on the High Commission's territory, it actually took place in South Africa. That's wrong as a matter of international law.
Well, but in any event, whatever took place at the Kilimanjaro airport, which is not within the High Commissioner's premises. Is that not so?
That is so. What took place at Kilimanjaro airport stems from what happened in Tanzania with meetings of the South African officials. It all comes down to this collusion, this agreement.
Handover and whatever she says regarding the activities that took place, the handover did not occur at her place, at her workplace. It happened at Kilimanjaro airport.
I think she handed over to the DHA to
that's
the High Commission. She handed over to the DHA at the High Commission. Am I right? Did she not hand her over to the DHA at the High Commission?
No, not the High Commission.
Only at the airport.
At the airport,
okay.
yes.
So what happened? The meeting took place at the High Commission.
And the point that I make is this: the handover took place on Tanzanian soil to South African officials. We say that's unlawful for the reasons I articulated. I'm not going to repeat them. Section 41 has no basis, and there's no other basis. There's no basis in law for DHA to have been there, from a South African legal perspective. The only basis that they point to is Section 41, which we all know was incorrect. The question then becomes, what was actually going on in the surrounding circumstances? And one of them is that which is suggested to be contained in paragraphs 9, 10, and 13 of the answering affidavit of DHA. So in paragraph 9 and 10, I've already told the court that she regarded the High Commission as premises of South Africa. In 13, this is what she says. It's astounding to me. And I accept unconditionally that the police can't answer this. They cannot, because it's not their case. But this is what he said. The agreement, and I emphasize agreement, not our words, but her words, between the Tanzanian authorities and the High Commission to deport. So it's an agreement to deport. That's unlawful on every international authority that there can be. An agreement to deport between two state entities back to South Africa, and this is the important word, was reached at the premises of the High Commission. I'm advised that once that happened, the appellant and Bester, as a matter of international law, were regarded to have been in the custody of the High Commission on South African soil. With the greatest of respect, if this court can allow that kind of thinking to permeate a case such as this, where the liberty of somebody has been taken away in the dramatic circumstances, and I cannot emphasize how important it is that this kind of thinking be dealt with in some type of order that the court makes, a la Morofontaine. It cannot be that these kinds of ideas permeate, and this is again questionable methods to wage a war against crime. The last point that's the one point that I wanted to make.
Yes.
The Moroklip point. The second point that I wanted to make was this, and I admit, and I have to accept, and I admit that I have some difficulties in making this point, but I do wish that the court has regard to what I'm now going to say in the context of which I'm going to say. The High Court judgment and order, the court will find in paragraph 290, the order's in 293. And the judgment starts in that bundle.
So
293 is the order, and page 251 is the judgment.
That's the leave to appeal
that's a
order.
leave to appeal.
So,
The judgment starts at 451.
oh yes, oh, sorry, that's the leave to appeal petition.
Yes.
Sorry, the judgment of the High Court, let me just, is on page
Order is 268.
268, which is just after, I just wanted to make sure I'm right here. On 268 is the judgment, that's correct, and that just follows the judgment. And on 268,
It's the order.
the order, yes, that's right. It's the same proposition as the leave to appeal in the other order, but it's important that this proposition is made. It is ordered that, one, and there's only one order, the application is dismissed with costs, full stop. However, in the judgment itself, on page 260, there's reference to an objection made by, I can't remember whether it was the police or Home Affairs. Yes, this is what happened.
Yes.
It wasn't the police, it was Home Affairs. Home Affairs objected to certain averments in the replying affidavit. In the judgment itself, on page 260, paragraphs 23 and 24, there's a suggestion that the evidence does not appear in the founding affidavit is prejudicial, etc., and therefore it was hereby struck out. And there's no order to that effect, other than contained in the judgment itself. I have to accept that. But it seems to me that nobody has objected, including Home Affairs, because they were party to the development of the record. So were the police. The police have not objected, it's done by agreement. In the replying affidavit, there are numerous references, which are, by the way, there are numerous references to annexures. The annexures are not attached in the record.
Mr. Kasa, I'm going to have to ask you,
Sorry.
what point are you making now?
I'm making this point. that the facts that the court will take into consideration include the facts that are contained in the record in the replying affidavit. Other than the annexures, you have to exclude the annexures. They're not part of the record because they were struck out. I have to accept that. Even though there's no order to that effect in the actual order. So there's no order to the effect that the facts, there's no order to the effect that the annexures to the replying affidavit are struck out.
No.
There's no order. So technically speaking, it could be argued that they should be there. But we haven't seized on that point from a what's the word, a cynical perspective and included them because an order wasn't made. What we have done is allowed the replying affidavit's contents, which include issues such as, on page 223 at paragraph 25, the Minister of Police explained how the arrest occurred. When? 8 April. The police tell us.
Sorry, Mr. Are you not arguing the new points now?
No, I'm making
it doesn't arise out of the reply.
It does.
Out of the
No, we submit that it does because what
correspondence argument.
the police say the following. It's a very simple case. This is what they say.
It is.
But they ignore it completely, and we say this court can't ignore what is said about what they say. If they had said, this is what we say, and this is the response, and this is why the response is wrong, context, or whatever, different story, but they don't do that. They say, this is what we say, full stop. We say, we submit, bearing in mind is what is said about what they say, objective facts. The court will not ignore those objective facts. It can't. They've given a full answer to what they say they said, and the court can't just ignore it. So they say, let's say for example, they say the moon is blue, and they say that end of the classical level. Let's assume they say that. But in the replying affidavit, we say, no, you say the moon is blue, but look, here's a photograph of a green moon. The court can't just say, well, the moon is blue as a fact. The court would have to say, well, what does this replying affidavit mean? That's the point that we make. You'd have to take into account what he said in the replying affidavit, a la Scots JA and all the cases. And again, I come back to Scots JA must be seen in the light of what he said in Zealand. And we disagree with the proposition that Justice Corwin put to our learned friend in that you have to go further in the Raven Decatio, because what Langa CJ says is that no, you don't have to go that extra step. In the Raven Decatio, you've got to say, I'm the owner and that person is in possession. And he says, the way I read the paragraph after the Raven Decatio reference, you don't have to make that extra step. That's how I read it. That's pleasing.
Thank you very much for the manner in which you've argued this matter. It's not an easy one. The court will consider and the judgment is reserved. Thank you, the court adjourns.